Hi, my name is Erica Morrison, and I am reporting on employment at will for Cornerstone University, class Business 661. So what is employment at will? The definition brought to us by R.L. Miller in his book Business Law Today defines employment at will as the doctrine either party may terminate the employment relationship at any time for any reason unless doing so would violate an employee's statutory or contractual rights. So why would an employer choose to be an at-will employer? They can therefore employ anyone who they think is the best fit for the position. They can also let an employee go if it does not seem to be working out. Being an at-will employer protects the company's time, financial resources, and reputation. In the book Decisive by brothers Chip and Dan Heath, they give an example of Zappos shoes. Zappos wants the employees to be a right fit for their company. In order to make sure that this happens, Zappos invites every employee to consider their position in the company after their orientation and training. If the employee feels it's not the right fit for them, they encourage them to take a $1,000 incentive to leave the company then and there. They feel that this, in the end, helps the company to be able to maintain the reputation in the community that they want and keeps them from getting a bad reputation by having an employee who does not really want to be there and does not fit into the position, the role, or the culture of the company. So why would it be good for an employee to be an at-will commitment or contract within the company? Employees benefit from at-will employment because it means that they can leave a job anytime that they feel it is no longer meeting their needs. Maybe the pay, it may be the responsibilities, the hours, the commitment, whatever the case, they can leave whenever they want. It may also no longer fit their goals. They may have matured in their position to the point where they can no longer work there. They can also sever the contract with the employer if the employer asks the employee to do something that is illegal or otherwise unconscionable. It also prevents employment discrimination. The Title VII Civil Rights Act, it also, through the Equal Employment Opportunity Commission, limitations on class action, intentional or unintentional discrimination, discrimination based on race, color, national origin, religion, gender, age, disability, etc. And it also prevents harassment in the workplace. Some exceptions for employers to the at-will employment exist in order to protect the employers and the employees. One of those exceptions is the contract theory or the implied contract exception. Another one is the tort theory. The third is implied covenant of good faith and fair dealing. And another one is public policy. All of these go hand in hand in order to protect both the employers and the employees. So what are some defenses for employment discrimination? Some possible defenses that employers might use if they are accused of discrimination in the workplace include business necessity, that their business required it, bona fide occupational qualification, seniority system, and after acquired evidence of employee misconduct. The Title VII of the Civil Rights Act gives employers the direct responsibility to make sure that discrimination does not happen in their workplace or employment environment. This is important to understand because such claims are based on acts whose very nature involves repeated conduct of intimidation, ridicule, or repeated insults. This is from the Cornell Law school. Employers cannot let someone go due to these following qualifications based on the Equal Employment Opportunities Commission. If someone is a witness in a complaint or an investigation, they cannot be fired. Communicating with superiors about discrimination also requires employers to not be able to let that employee go. If an employee refuses to follow orders that go against what they feel is conscionable, an employer cannot let them go. Resisting sexual advances for men or women in the workplace cannot result in someone being fired. And requesting accommodations for disability or religion. So my conclusion to the employment at will policy is that it is good for both the employers and employees because it protects both parties equally. It gives employers some options on things that they can do, some retaliations that they can go through if they do need to let someone go, but it also gives employees power to be able to refute that discrimination or that letting them go in order to have the best employment situation for themselves. It is important, though, for both employers and employees to do due diligence in order to make sure that they are covered legally and that they do have a way to refute discrimination in their employment situation. Thank you for taking the time to listen to my presentation. I have appreciated it. Again, this is Erica Morrison for Cornerstone University.